You're live, Judge.
I'm live, okay. All righty, let's go on the record. If we could have plaintiff's counsel make their appearance and announce the cause number and the style of the case.
Morning, Your Honor. Brant Martin, Ethan Minchell, and Paul Elkins with Wick, Phillips, Gould, and Martin on behalf of plaintiffs Manpal LLC, United Investex 7 Inc., and United Investex USA 11 Inc. That's cause number DC-20-08635.
Okay.
And Your Honor, we've got Mark Katz and Maria Garrett here on behalf of the defendants. Also with us, excuse me, Your Honor. Also with us is Ryan Lantry, who's one of our summer clerks.
Mr. Lantry, where do you go to law school? I don't see you.
Good morning, Your Honor. I go to Washington University in St. Louis.
Ah, had some great interns from there. It's a very good law school. So welcome to Texas.
Thank you.
All right, let's get started.
And Your Honor, we do have a brief PowerPoint. If Your Honor is all right, if I can share my screen. And
absolutely. Let me go ahead and enable that. Let's go ahead and proceed.
All right, thank you, Your Honor. So we're here on two motions: a motion to dissolve the TRO and a motion to stay this case. In a nutshell, Your Honor, we have two grounds for the dissolving the TRO. The first is that the contracts that are the basis of the action that the plaintiffs have filed, that were the basis of the TRO, have been superseded by prior agreement, by subsequent agreements. There are enforceability issues with those agreements, which is why I expect the plaintiffs did not proceed on them. But regardless of that issue, they were not the basis of the application for the TRO. So the short story is the agreements that were the basis for the TRO are not in force and effect. Additionally, the way
Mr. Katz, is that true for all the defendants? Because it seemed like some of them you didn't have copies of the agreement for at least one of the defendants. Is that not right?
It is correct, Your Honor. We had copies for two. The third was produced by the plaintiffs in the expedited discovery process. So we now have all three agreements okay. For each of the three defendants. And then the other issue we have with the TRO is that it seeks to restrain our clients from engaging in competitive activity with respect to a list of entities that is subject to an AEO designation on a protective order, meaning that my clients are purportedly subject to a TRO, but they have no knowledge of what the restraints are, and they're not allowed to know. And as we'll argue in a moment, that creates the issue that you've got a TRO that's purports to incorporate external documents, which would render the TRO unenforceable anyway. But then additionally, you've got a TRO that can't be complied with in any just way. So for both those reasons, we've sought to dissolve the TRO, and additionally, and perhaps more importantly, this case should be stayed. There was a prior case filed by my clients in California.
Mr. Katz, I asked prior counsel on this about that exact issue, and I said, hey, are you guys going to be moving for an anti-suit injunction here because there's a prior case in California, or am I able to go forward with this? And they said they were not going to be doing that. And now that we have new counsel, you guys are saying that you are going to be doing this. And so I acted kind of in reliance on previous counsel statements that they were not going to be seeking this type of remedy. And now you guys are doing that.
Sure, Your Honor. And I understand. I think maybe part of the confusion came from the anti-suit injunction question. We don't have there was a transcript of the hearing, so I'm not fully apprised on the full extent of the discussion, but we're not seeking an anti-suit injunction. If the plaintiffs in this case want to seek to enforce these agreements through injunction or otherwise, they are free to do so. It just needs to happen in California. And the issue we've got in California is the same parties, it's the same contracts, it's the same issues, and they are issues that are to be determined by California law and pursuant to California public policy, and which require that these issues be resolved in California. And so I apologize for the inconvenience on the court and perhaps any miscommunication on the strategy. But again, I think that had to do with the whether there was an intent to seek an anti-suit injunction, as opposed to these are claims that must proceed in California. And again, Your Honor,
is there a choice when you say it must prefer? Is there a choice? I thought there was a choice of venue that should be in Dallas. Is it supposed to be in California?
It is, Your Honor, and that dovetails on the issue of the contracts being superseded. Is by California. You're correct, Your Honor, that there is a choice of law and choice of venue provision in the contracts for Texas. Under California statute, those are per se unenforceable. California statute requires or invalidates any choice of law provision like we have in these contracts, and that statute was enacted in 2017, which it perhaps may be the strategy reason why the plaintiffs proceeded on the agreements that they did, which were executed in 2015 and 16, as opposed to the contracts that superseded those. The live contracts were executed in 2018. Now, even irregardless of the statute, the California public policy under common law pre the statute would invalidate the choice of law, choice of venue provisions anyway. That does not mean just because the venue provision is invalid does not mean that there's not a situation that a case could proceed in Texas. It just means that it's not mandated to be in Texas by the provision. And again, we've got a first filed case in California, same parties, same issues, with all the attendant risks where you've got the potential for inconsistent judgments, certainly additional use of the resources from the courts, and there's certainly no reason why this can't be in California. I'd also note, Your Honor, the plaintiffs, 2 of the 3 plaintiffs are California corporations. All 3 of the defendants are California residents, and they worked in California during this time. All of these issues are in California. I'd also note, Your Honor, that the two defendants that are the 2 plaintiffs that are California corporations are not even registered to do business in Texas, and certainly weren't at the time that they filed this lawsuit or sought the TRO. The overwhelming connection to this case is in California, which is just another reason that these issues should be resolved in California. But if Your Honor is okay, I'll because I appreciate Your Honor is familiar with the issues and has obviously read the pleadings, and we've just discussed a lot of what's in the PowerPoint. But if Your Honor is okay, I will just touch on a couple issues here, Your Honor, just from the employment agreements that are subject to this lawsuit here in Texas and underlie the TRO are these 2015 and 2016 employment agreements. And then in 2018, all 3 of the defendants signed what were titled confidentiality agreements, but contained similar provisions and integration merger clauses that I'll go through real quickly here in a moment to show that they supersede the prior ones. And then the California lawsuit, just so we have it on the record, was filed on June 12th. It's got the same parties, again, same issues. The Texas lawsuit was filed 11 days later on June 23rd. The law obviously supports the superseding of contracts that are dealing with the same issue. Also, certainly permits the contracts to themselves have an integration clause that that mandates superseding any prior agreements. And our 2018 agreements here have that integration clause that clearly says all of the understandings, representations between the employee and the employer pertaining to the subject matter hereof, and supersedes all prior and contemporaneous understandings, agreements, reps, and warranties, both written and oral, with respect to the subject matter. Your Honor asked about all three of the defendants. They all signed the agreements. The definition of the employer in the 2018 agreements is specifically incorporated the corporate affiliates, which are all three of the plaintiffs here. So we've got we've got all three of the plaintiffs under the confidentiality agreement again, and then therefore superseding any agreements with any of those three entities on the same subject matter. And so here's the subject matter, Your Honor. The agreement on the left, the language on the left is from the 2015-16, and this is what's been sued on. Non-solicitation, employee shall not directly or indirectly solicit, entice, persuade, or induce, call upon, and provide services to any of the customers, i.e. investors or accounts that employee service, called upon, learned information about through employees' employment with the company. That's the provision that that's been sued on here. I also note as a side note, Your Honor, but an important piece of background, the application for the TRO does not include any information suggesting that or demonstrating that any of my clients have solicited any customer or investor. What this case is really about, they have issues with documents and information that they claim my clients took post-employment. There's a dispute about that from a standpoint of who owns that information. And all of that, all of those issues are being litigated in the California case. And and there's no misappropriation claim here. There's nothing to do with taking information. Again, I think my clients will prevail on that issue in California, that they are the ones that own that information. But that has nothing to do with the non-solicit, which is factually another reason that there's no need for the TRO. But the non-solicit in the 2018, again, is broader than the 2015/16 one, and it provides, again, a non-solicitation of customers is what it's called, talking about the same thing, and they will not directly or indirectly solicit, contact, or attempt to solicit or contact any of these individuals. It's got a broad definition of them. They can't even meet with any of the group's current, former, or prospective customers for the purpose of offering or accepting goods or services similar to or competitive with those offered by the employer group being the plaintiffs. So, Your Honor, I don't think there can be any question that the subject matter by the 2018 is the same subject matter of the prior agreement and supersedes that. And I think it's telling in the plaintiff's response to our motion, they did not even argue that that was the case. And then the other issue we mentioned on the TRO, Your Honor, is that it seeks to incorporate by reference to another document, this AEO list, which we believe would render the TRO invalid on its face. We did not even
receive. With Mr. Katz, this was something that was agreed to by the opposing side. I mean, this is.
Your Honor, well, I hate to be coy. I mean, and I don't know that this was the case, but I think if the plaintiffs wanted to agree to an unenforceable TRO, that's what they could do. But the issue is, Your Honor, is, and we didn't even get the list, for example, until over a week after the TRO was entered, and we're not permitted to communicate with our clients about that list. There's no way that they can have any knowledge of who's on that list or what they're restrained from doing.
I mean, the alternate, Mr. Katz, that we discussed was if we don't have a list, then it would be for everybody. And we were trying to provide some degree of certainty and really trying to, it's kind of one of those no good deed goes unpunished. We were trying to give them the ability to work with people who are not on the list, as opposed to just some universal, vague, no customers, and they may not even know who the customers are. Now, I don't know what the agreement was about attorney's eyes only, if they weren't allowed to look at the list, or how they were supposed to know. I don't know the details of that because I don't recall discussing that, or maybe we did discuss, I just don't recall. But this was something to try to protect your client from, and provide some degree of certainty. So,
Well, I appreciate that. I guess I would say we've raised this issue with plaintiffs' lawyers, and it was never. I was certainly unaware of any conference on this issue or this format of doing it. I certainly would not have agreed to it because it's not workable. There are, and I would respectfully suggest, Your Honor, that a TRO that just says broadly don't solicit customers would equally be unenforceable because it wouldn't specifically identify the acts to be restrained. Certainly there's ways to do this in an appropriate fashion. But again, respectfully, this is not one that gives our clients any indication of what they can do or can't do. And I don't think that
it is the problem with this that, and again, I don't know what's in the AEO, is that your client is not allowed to see who's on the list. Is that the problem?
That is the problem, Your Honor. Yes.
Okay. Yeah, that is. I didn't know that. That is a
And
problem.
and we have separately well, we haven't filed. I'm sorry, Your Honor. We have, under the terms of the protective order, which allows a challenge of the AEO, we have started that process. And again, I think this is a little bit of a side issue because, again, these are all based on contracts that are not even in effect. And under California law, even if they were in effect, because the choice of law is not enforceable, they're under California law. They are the restrictive covenants are per se invalid under California law. And again,
do both agreements? I know that at least one of the agreements has a choice of venue here in Dallas.
Mm-hmm.
Do they also have a choice of law for Texas?
They do, Your Honor, which is
both agreements.
Yes, Your Honor. And if I can jump ahead just so I can address that issue. Here is the statute at issue that prohibits an employer from doing what exactly the plaintiffs are trying to do here, which is to require them to adjudicate outside of California a claim arising in California, and then to deprive them from the substantive protection of California law with respect to the controversy arising in California. And so these agreements, and then under, and perhaps even more significantly, and I'm not sure if we cited this, I apologize, Your Honor, and but California has a non-compete statute that specifically provides that there's only narrow exceptions, i.e. the sale of a business, where you can have a non-compete or a non-solicitation of customers such as this. And so again, that's what's going on here, Your Honor, is that we've got litigation in California over these very agreements with these very parties. The plaintiffs don't want that issue resolved under California law because there is no question that these agreements are not enforceable under California law. So they are trying to bootstrap through the choice of venue provision litigation here in Texas to ignore those the California provisions, again, which and they don't even argue in their response that these agreements are enforceable under the California statute that invalidates non-compete and non-solicit agreements that are not in the sale of a business. They cite in their response to a general proposition that California courts will enforce contracts. That's obviously a very different issue than we're here for. And again, all we're talking, about here is the TRO and the stay. On the TRO, that was based on these 2015 and 16 agreements, which have been superseded. And I, respectfully suggest that Your Honor would have liked to know at the time that you entered the TRO that there were agreements that were entered 2 or 3 years later that had that integration clause and the same subject matter restrictions that
I guess I'm not exactly clear though. If the new agreement also had a choice of law in Texas and a choice of venue in I guess in
Right.
Dallas or Texas,
Yes.
and it also had a non-solicitation. I mean, what is the big difference between the two agreements?
There's not, which is why the second one prevails, and there's no application for TRO on the second one. But Your Honor, this statute says you cannot have an agreement like this with that was executed after January 1, 2017.
Oh, it's because of this. Okay.
Yeah. And so you can't enforce either of those. And there's also, and I've glossed over, Your Honor, and I know I've taken a lot of the court's time, and I want to be respectful of that. It's very clear that California has a very strong public policy to protect its citizens with respect to non-compete agreements, and meaning that they get to be resolved in California under California law. And Texas courts, as well as California courts, recognize that when there's a first filed case on the same issues, same subject matter, that the first filed case is where the suit has to have, especially when there's an important public policy interest at play, which we've got here. That we've got. I believe these agreements are certainly overbroad, if not unenforceable under Texas law, but there's not even a question under California law, and again, we've got a lawsuit in California about the same agreements, and that's the plaintiffs are free to pursue their claims. Again, 2 of the 3 plaintiffs are California corporations. All 3 of the defendants are California residents and lived in California during the relevant time. This is just a matter of they need to proceed with their claims out there. And ultimately the reason they do not want to do that, Your Honor, is they understand that they don't have a leg to stand on under California law. And so they're hoping to try to thread the needle here and have Your Honor apply Texas law and to try to enforce agreements.
Have there been any cases? This is, this really calls into question some very interesting choice of law issues, because usually a choice of law and choice of venue clause in Texas is going to be enforceable. One of my first cases I ever worked on as a judge involved a very complicated case involving a choice of law or choice of venue clause between the Indonesian National Oil Company and the Chinese National Oil Company. Involves gas leases off the coast of Indonesia, and the Texas Supreme Court, I recall, reversed my predecessor, and I would have done the same thing he did, that said, hey, Texas has no interest in this, but they said, hey, there's a choice of venue clause, you need to go, this case needs to stay in Texas. Can another state just say, we're going to invalidate principles or invalidate contracts like this in other states? I mean,
yeah. So Your Honor,
a little has a Texas case has a Texas court ruled on this provision? I guess
I would say yes, Your Honor, in this way. That the difference here, it's not a black and white rule that choice of law, choice of venue provisions are never enforceable. Other than if you've got a non-compete contract like we've got here, that's subject to California law, it is invalidated. But the reason it is because, like, for example, Your Honor, the case that's cited at the bottom of the slide, that where you've got a Texas court recognizing that California has that Texas non-compete law is contrary to the fundamental policy of California. So the reason this is important is that there is a fundamental public policy interest of California in protecting its citizens with non-compete agreements. This is a Texas court recognizing that California has this fundamental public policy. And the reason that that's important is that is the
Is that
issue
a
of,
case though, where there's a choice of law provision within the contract that you apply Texas law in the case you just showed me?
well, I need to do two steps to get there, Your Honor. So the reason is that you've got, so to back up for a second, the standard under the first filed rule and the stay is that, and Texas courts recognize this, is that if enforcing the agreement would contravene the public policy of the other state, that's when you do not enforce the underlying provision, whether choice of law, choice of venue. And that's what we have here, is that you've got enforcement of these provisions would frustrate the public policy of California, which is why they can't be enforced. You know, they're also, but we don't even need to get into that type of an analysis because we have a simpler case, Your Honor. We have the case filed 2 weeks earlier that has claims about the same contracts, and Your Honor doesn't even need to decide that I'm going to ignore choice of law, choice of venue. All Your Honor has to do is stay the later filed proceeding, your proceeding, while the prior proceeding pushes forward.
May I be heard, Your Honor?
Did you have anything else, Mr. Katz?
Well, I mean, and I know I've taken a lot of the court's time. I'm happy to talk about the public policy interests and the connections to California, which are overwhelmingly in favor of California. If Your Honor wants to hear that, but I'll let Mr. Martin have a turn.
Let me hear from Mr. Martin now.
Thank you, Your Honor. I'm glad to hear Mr. Katz use the word respectfully because, quite frankly, his motion was anything but respectful. The fact is that Mr. Katz's firm right now is wrong on the facts. He's wrong at what's at issue in this lawsuit. He's wrong on the law. He's wrong at what's at issue in the California lawsuit. And he's certainly wrong in accusing my firm of being, let me quote, deceitful, misrepresenting things to this court, or hiding things from this court, which happened at least 4 times in their motion. He's wrong in the facts because these agreements are not superseded. On page 9 of their own motion, let me quote, it says, to Your Honor, the primary difference between the 2 versions of the agreements is that the earlier agreements specifically include non-interference language. The 2018 agreements, which are the agreements Mr. Katz wants this court to focus on, the 2018 agreements remove that language and focus instead exclusively on non-solicitation of customers. So the agreements are separate. They do have independent covenants. And to that point, Your Honor, I was very clear in both of the previous hearings. And I'll give Mr. Katz the benefit of the doubt because he was not here and there is no transcript of those proceedings. But I think Your Honor will remember, I was very clear as to what we were suing on and what we were not suing on. We never hid anything about the California action. And let's talk about the California action for a second, because Mr. Katz, in his motion and in his reply, focuses on public policy of California, and these are unenforceable in California. No, they're not. What is unenforceable in California are non-competes, and I agree with that statement. And I was very open with the court that we were not suing on the non-competes. Mr. Katz is conflating the case law surrounding non-competes, and he's trying to wedge our lawsuit into that public policy. But that's not what this case is about. And I was honest from the very beginning. This case is about the non-interference with the relationships. That's what we sued on, and that's what we have venue on. Another thing that Mr. Katz left out, talking about the 2017 law and whether or not it is enforceable and whether or not Texas has to follow California's lead, it honestly, Your Honor, doesn't matter because the contracts that we sued on were signed prior to January 1, 2017. And the statute that Mr. Katz put in his PowerPoint, the exact language says that those contracts that provision on the venue provision only applies to contracts that were signed or modified after January 1 of
But
2000.
it does appear like that previous contract was superseded by the new contract because it
It
has.
doesn't, Your Honor, because Your Honor, I disagree. Frankly, I disagree. The previous contract was an employment agreement. The contracts that Mr. Katz is talking about are confidentiality agreements. The confidentiality agreements do not replace the employment agreements. And the employment agreements have their own independent covenant regarding non-interference with relationships. That's what we sued on. Those were never superseded. And in fact, Your Honor, I would point you to the exact case that Mr. Katz cites, which is the Allen Drilling case. It's out of the Waco Court of Appeals, 2018. That case specifically says, and if I may, Your Honor, I'll read it to you. He's talking about superseded agreements. And the court says, there is no express language in the new agreement that states the party's intention to supersede the original agreement. It does, and it had a merger clause. And the defendants in that case, the other side was arguing that the subject matter was the same, but the court found that it wasn't. And the reason it did was it said that when the terms of one contract are so inconsistent with those of the other that the two cannot subsist together, is there a presumption that the second superseded the first? There is no such inconsistency here, Your Honor. These are independent covenants. And I would point out to the court that at this stage in the proceedings, that's what matters. It has to be a finding of law that there is absolutely an inconsistency which would cause the confidentiality agreements to supersede the employment agreements. One, that's not the case. And I think, Your Honor, when you read the contracts, you'll see that. But second, regardless, that is way on down the road where they have to prove that these are so inconsistent. Quite frankly, Your Honor, they're not. And if they're not inconsistent, all we're asking the court to do is preserve the status quo. That brings me back to the California case and the conflation of California's policy against non-competes with California's policy related to everything else. Mr. Katz wants to say first filed lawsuit, first filed lawsuit. We were there 2 weeks before. But as we pointed out to the court when this first came up, again, we were not hiding anything. Their lawsuit in California that supposedly established the jurisdiction only asked for declaratory relief that the non-compete and a 14-day waiting period not be enforced as being contrary to public policy. We have stated in our papers, I am sure if I try to take an inconsistent position, Mr. Katz will point it out. We are not trying to enforce the non-compete. We've never tried to enforce the non-compete. We're not going to enforce the non-compete. The non-compete is subject to the California policy of not enforcing non-competes. That's not the restrictive covenant we're trying to enforce. And trying to conflate the entirety of restrictive covenants into the California policy against non-competes is, quite frankly, a misstatement of California law. And I've litigated this case out there quite often. And those are separate doctrines under California law. Under California law, a non-compete is unenforceable because they don't want to keep anybody from working. But the California cases are also very clear that other restrictive covenants will be enforced. Mr. Katz's argument, I get it. It's the argument I would make is these superseded it. But the language of the contracts actually runs counter to that. And the language of his own case, Allen Drilling, runs counter to that as well. Unless the contracts are directly contradictory, if the contracts and the provisions can exist independently, then neither one supersedes the other, absent superseding language in the document, which this isn't in there. Your Honor, as to, and I don't know what else you want to hear about, the other issues you want to hear about, the lick log here in my mind is whether the court thinks these contracts superseded one another or not. They don't. The rest of this is noise. Quite frankly, their California lawsuit doesn't even have a live case or controversy. And I'm sure the response to that is going to be that they filed for a motion for leave to amend. That hasn't been granted. There is no live pleading in California that deals with these issues. The California lawsuit also has additional parties that we did not sue. We were very careful to sue on the contracts for which we have independent causes of action and we have venue because they were executed prior to January 1st of 2017. They were not changed after January 1st, 2017. They were not executed after January 1st, 2017. And the confidentiality agreements do not get rid of the employment agreements. I sued on the employment agreements. The employment agreements have a choice of law and a choice of venue here in Texas. I get it that they want to be in California, but that does not vitiate my ability to bring my lawsuit where I want to, where there is proper jurisdiction and proper venue. It's really, Your Honor, that simple. We sued on distinct covenants, which I told the court from the very get-go. We sued on very distinct contracts. And when Your Honor asked their previous lawyer, are you guys going to do an anti-suit injunction? And he said no. That's what he said. I'm not going to try to claim estoppel like they put in their papers. I'm not going to try to claim judicial admission. I think it was not a very smart answer, but regardless, that issue was before this court. And I was clear when that discussion came up. I said, Judge, it doesn't matter if they did or not. This is a separate cause of action under separate contracts. I hold to that to this day. We were very upfront with the court and what we were asking for and what we were suing on. We still are. We haven't changed one bit of our strategy simply because they don't want to be in Texas. Doesn't mean they didn't sign an agreement which subjected them to jurisdiction in Texas, regardless of any intervening changes in California law. But even those changes didn't affect the enforceability of the venue provisions, the choice of law, and the independent covenants that exist in the employment agreements that they signed in 2016. And all we are asking is for this court to maintain the status quo under those agreements until Mr. Katz and I can fight all of this out on the merits.
Yeah, Your Honor. Thank you. Okay, so Mr. Martin, albeit passionately here, misses the point on the superseding, and I think Your Honor picked up on it. What Mr. Martin is talking about is language in the case that deals with what I would say common law superseding. When does one contract supersede the other? This contract, we know when it does because the integration and merger clause says it supersedes all prior understandings on the same subject matter. I showed Your Honor the language. They're taking this torture provision and saying because the non-solicitation in the earlier agreement was styled as non-solicitation and non-interference, that somehow allows them to sue under non-interference, but not non-solicitation. I mean, that's an extremely tortured view. That would be an extremely perilous position to allow them to proceed on, okay, what is an interference that doesn't amount to a solicitation as that term is defined in the second agreement, which I showed Your Honor is extremely broad and clearly covers the issue. There's no doubt that the second agreement superseded the first. And the reason that we were very strenuous about this in the motion is that when I saw these substantive agreements, the first thing I did was reach out to counsel for the plaintiffs and say, because I assumed they were not aware of the agreements. And I was surprised, to say the least, when they said, no, we're aware of the agreements. We considered that and decided to sue on the earlier ones anyway, which is why I think to me, it is very questionable, Your Honor, that they didn't bring those agreements to their attention. If Mr. Martin was as forthcoming as he indicates he was, why didn't Your Honor know about those agreements? But regardless, the language of those agreements supersedes them, and that ends the whole inquiry. These issues are absolutely at issue. All of the agreements in the California case, we're happy to provide, Your Honor.
What do you make of this argument that that this really doesn't cover the non-compete, and the non-compete,
right? Yeah.
Case in California only covers the non-compete.
Right. So it doesn't, Your Honor. The case in California covers all of the agreements, the non-competes and the non-solicit. And here's where I think Mr. Martin is conflating the point. In California, and we can provide case law to Your Honor, and under Mr. Martin's argument, that I think that should also end the issue. In non-solicitation agreements, provisions like here are considered non-competes under California law. And so for Mr. Martin to say that they are okay with the non-competes, but they want to go ahead and sue on the non-solicit. Under California law, the statute that covers non-competes it covers, and the case law is very clear in this way, non-solicitation agreements like this. And so they do cover, when you, in California, the term non-compete covers non-solicitations and non-competes. And again, the only, and the common law that was codified in 2017, but the common law in California was the same before that. The only situation where you've got a non-compete / non-solicit, because it's the same thing in California, is subject to the same standards that can be enforceable, is in the sale of business context. You can't have it here.
Mr. Martin, do you agree with that it's treated the same way?
I disagree with a couple of things he's saying, Your Honor. One, he's now inserting the term non-solicit. I think I was very clear. Our cause of action is for non-interference. Again, from the very first hearing, I said, this is what we're suing on. And if you look at our pleadings, that's what we're suing on. I also disagree.
Wait. You're jumping. So what is the difference between non-solicit and non-interference?
I think that's a subject for another day, quite frankly, Your Honor. I think if we're getting into what is the definition of subject matter in terms of subject matter being superseded, that hasn't been briefed, and let's fight that out another day. But I do think that non-interference and non-solicit are different. I think it requires a very exhaustive survey of California law and how the California courts distinguish between those, because frankly, I disagree with Mr. Katz's kind of blanket statement that California doesn't enforce any non-solicits. And for that point, Your Honor, I would point the court to another case that they cited, which I believe is also incorrect in what they cited it for. And of course, now I'm going to lose my train of thought. I apologize. I'm going to have to, let me come back to that point, Your Honor. I'm going to have to find it here in a second. The fact is that non-competes, non-solicit, non-interference, those are all separate duties. They're all separate covenants. They're all separate provisions. Texas treats them differently depending on the context. California treats them differently depending on the context. What the California law doesn't ever say is that all restrictive covenants of all types are never going to be enforced. That simply that is not what California law says. California law is very clear that there are restrictive covenants that will be enforced, and we are enforcing one of the ones that's not in contravention of public policy. So to answer your question more succinctly, I disagree with what Mr. Katz just said. I also disagree with his characterization of our claims.
And Your Honor, I think it's interesting that Mr. Martin can't tell you what the difference between non-interference and non-solicitation, but he's asking you to enter or to keep alive a TRO that he says prevents my clients from interfering, but I assume he would admit it can't prevent them from soliciting. Again, we don't even know what we can do or can't do for a whole variety of reasons. Again, we don't need to get to any of those issues because the contract superseding ends the analysis.
Yeah, I mean, I've been doing this a long time. I don't really know the difference between interference and solicitation either.
I think, Your Honor, that would require an exhaustive briefing on the distinction between all of them, and that's not what we're asking for right now, nor is this a summary judgment proceeding. If he were to bring this as a summary judgment on our claims can't stand because they were superseded and these causes of action fail, that's a different type of briefing than saying, Judge, we want you prima facie to enforce the status quo regarding independent obligations under enforceable contract, because that's what we're asking for.
All right. Okay. This is an interesting issue. So what are the motions here? We have a motion to dissolve and what else?
There's a motion to dissolve and a motion to stay, Your Honor. They both deal with the same issue. And what we're asking for is for the court to go ahead and proceed with the temporary injunction, which we'll do now under the extension in a couple of weeks after we get the depositions. And then whatever Mr. Katz's friends in California they bring in California. We perhaps have to fight that out, but it has nothing to do with these obligations.
Well, and Your Honor, I would say that I think
Mr. Katz, just so I want to make sure I'm on the same page here. So if I understand the procedural position right now of the California case is there's a cause of action saying that the non-compete is unenforceable under their Declaratory Judgment Act in California. There isn't anything about non-solicitation or non-interference. Is that right?
That's not correct, Your Honor. So the original complaint that was filed talks about the non-compete provisions, in plural. Then there was, and again, under California law,
What is the basis of the motion for leave to amend?
there's a whole we're just so you honor is we're not representing my clients in California. We're not parties to the action, but there are a whole variety of other claims that have been raised. In the amended pleading, there was for clarification, because when we raised it with plaintiff's counsel in this case, that's when the first time we understood they were taking the position that the non-solicitation provisions were not in the California case, which and it's attached. Both of the original complaint and the amended complaint are attached to our briefing in this case, so Your Honor can look at them and judge for yourself. But certainly the amended complaint clearly indicates that those are at issue. The
solicitation and the interference.
Yes, Your Honor, and we have Texas case law, if Your Honor wants, that shows that even if the claims were not in there originally and then they were added later, that doesn't change the impact of the first filed case. These issues still need to go to California. We have Texas case law on that, and I'm happy to provide that to Your Honor and to Mr. Martin.
Your Honor.
If you want.
Okay, I'm going to go ahead. This has gone way longer than it was scheduled for, unfortunately. So I'm going to go ahead and rule now. I'm going to grant the motion to dissolve. I'm going to deny the motion for stay. I want to find out what's going on with this motion to grant leave. I don't really understand why that hasn't been granted in California. And I do want additional briefing on this issue. So,
Your Honor, may I ask the court, you're going to dissolve the TRO while we continue to, I mean, that's just going to force us to come back and apply for another TRO based on the briefing on the same issue. I'd rather the TRO.
You can bring it. I think I've made clear what my position is at this point. I feel very uncomfortable. I don't know. I've been doing this a long time. I've never heard anyone try to make a distinction between solicitation and interference. I anticipate that if the California court does grant the motion for leave, I probably will not. This is not a ruling, and don't say, Judge, you said that you would do this, because I don't know for sure. But I'm leaning towards at this point staying this case. I think this case probably should be in California, but given the distinction at this point, you can file a new TRO. I don't think anything's going to change at this point. You can provide. I think the most important thing you do is provide briefing to explain what the difference is between interference and solicitation, because I always understood this to be a solicitation case. So anyway, motion for dissolve is granted, motion to stay is denied. Just get me an order on that. Go ahead and email it to my court coordinator, and you guys be safe. Okay.
Thank you, Your Honor.
Thank you, guys.
Thank you.
All right. Did anyone here show up on the dismissal docket that wasn't here earlier? No? Okay. Anybody here on the share screen. Anybody here on the Bawa versus Rodriguez case?
Yes, Your Honor, I'm here on that and present on that case. Attorney
Okay.
Makia Dawkins.
Anybody for the defendant?
No, I'm for the defendant, for
there
Mr.
anyone for the
Rael
plaintiff?
Nieto.
Is the plaintiff represented?
They are representing themselves. We have sent out notice of the hearing. I have the FedEx confirmation numbers. We did e-file notice, and I actually called the plaintiffs and confirmed with them that they had the phone number to the court coordinator and the login instructions for Zoom. And they called again this morning around 9:15, and they confirmed they had it. So.
But they're not here right now. Is Mr. Bawa, or is it Bawa? Is that the name?
Yes, and only Bawa returned the call. The other person didn't return the call, but no one filed a response for the motion or anything like that.
Okay, great. Let's go ahead and proceed.
Oh, yes, Your Honor, I filed a motion for summary judgment on the traditional summary judgment standard, and then also for the no evidence. We've been set for trial a few months. They previously had an attorney. I think the attorney withdrew uh, based on, I guess, lack of communication. And so we hadn't been able to pretty much get anything done with the case. And so from our understanding that all the discovery has been completed. And I ask this court to grant the defendant's motion for summary judgment.
Okay, and there are, well, the other person's a minor, is that right?
So for MB, yes, but so Ravanaki and Bawa is, I think, is next of friend for the minor.
I don't feel terribly comfortable doing a DWOP of a minor's claim, or sorry, summary judgment in this situation for a minor's claim.
And the parent, I mean, the guardian did know. I mean, I did talk to Bawa, and I actually have their voicemail from this morning that I did return their call stating that they knew about the motion for summary judgment. I did let them know that they should, because they did have an attorney, but I did let them know that when I spoke to them last week that their response was due if they were going to file a response. And I didn't get any type of inclination that they were opposing the motion or anything like that.
Okay, all right. I'll go ahead and grant the summary judgment. And all right. Well, that said, I'll go ahead and sign that and we'll get that scanned in by tomorrow. So just be safe out there, and we appreciate you showing up. Okay.
All right. Thank you, Your Honor. You have a good day.
You have a good day. Bye-bye. All right. Next case. Anyone here on the dismissal docket? Okay, I think the next hearing is at 10 o'clock. We're a little behind. Is anyone here on the Jorge Levy family limited partnership versus CKN Land Partners GP LLC at all?
Yes, Judge. I think both parties are here.
Okay. Do y'all want a record for this? We are on Zoom.
I'm fine with there not being a record.
Mr. Mathis, I think you're muted.
Sure how to fix this problem.
I just unmuted it.
I'm sorry. Okay. I don't know what happened to the video. There it is. That seems to have done it. Good. Okay. I'm still learning how to do this. How are you this morning, Ron?
Good. How are you?
I'm surviving.
Yeah, it's we're spending a lot of time on Zoom lately. It's kind of the wave of the future. So, all right. So, motion to compel filed today. Is that correct?
Yes, Judge.
And Mr. Mathis, did you say if you wanted a court reporter?
I don't care about a court reporter at all.
Okay. Let's go ahead and get started. This is on YouTube, though.
Okay. Judge, I served discovery back in April of 2019 relating to this post-judgment proceeding. My client at the time had a judgment for over $900,000. Jeff Gilbert then filed a notice of bankruptcy proceeding, went through the bankruptcy case, received a judgment of over $800,000 in the bankruptcy case. And when we were knocked back down to the state court level, the lawyers on the file communicated with Jeff Gilbert's then attorney saying, hey, well, you never answered this April discovery. now that we're back in the state court, you need to answer the discovery. And a couple of months followed. Then Mr. Mathis got on the file and sent me what purport to be responses from Jeff Gilbert. Unfortunately, I just think they're woefully deficient. He's very vague about what assets he has. And so I would like an order from Your Honor requiring him to fully answer the interrogatories and requests for production. I'm going to try to share my screen to show you what his answers are.
Okay. It's enabled.
This one.
Have you guys conferred on this yet on each individual request?
We conferred generally, but we unfortunately the interrogatory answers and production responses weren't given to me until Thursday or Friday of last week. So I was not really able to go through it with Mr. Mathis in detail, what the issues were. I'm happy to do that now, and perhaps we can reschedule another Zoom hearing if necessary.
I mean, there's a couple ways we can do that. We can go ahead and, Mr. Mathis, do you want an opportunity to confer more, or do you feel like?
I absolutely do, but I would like to respond to that because I don't think it accurately represents what's happened here. I recently appeared in this on behalf of Mr. Gilbert. His former bankruptcy lawyer asked me to get involved and help after this motion to compel was filed. The problem is Mr. Gilbert doesn't have anything anymore, and so the answers that may appear to be limited are just because there's nothing there. This judgment apparently is the only thing that survived the bankruptcy. Immediately when I got involved, I explained to Mr. Gilbert he had to go back and answer these old interrogatories that preceded the bankruptcy. He agreed to do that. We prepared responses. Mr. Jordan raised a question about sufficiency. I reviewed them again and then modified 2 of the answers. I found the missing documents and produced those. And then there was an exchange of emails asking that he specifically tell me which ones or what he thought was deficient, and I got no reply.
That was Friday afternoon.
Can I please finish? Then he asked for his deposition, and I agreed that Mr. Gilbert would give his deposition. And in fact, we scheduled a date for Mr. Gilbert's deposition. And the motion to compel today in no way addresses the sufficiency of the answers. It's purely a motion to compel him to respond. So I would ask that the court not do anything, that we confer about these, and specifically that Mr. Gilbert give his deposition. Mr. Jordan can explore and probe all of these answers all he wants in the deposition. And then if there's something remaining after that, well, we can come back.
Judge, I was happy to confer before that. I don't know that conferring is really going to get us anywhere after that type of response, but may I address some of the points that he made in that?
No, I'm going to have you guys confer. So you have a couple options here. I can send you to a breakout room right now, and then I can bring you back.
Happy to do that, Judge.
Do that, or if you guys just want to come back this afternoon and come back to the same Zoom link, you can do that. Whatever you prefer.
I'm happy to do the breakout room, Judge.
We can do it right now.
Okay, let's go ahead and. It's always a little tricky. Okay, so I'm going to go ahead and send one of the interns, Julie. I'm going to send you with them. Text me when you want to come back. So I'm going to send all 3 of you, and then once they're done with their conference, just text me and I'll bring you back. Sometimes I can do this and sometimes I can't. So let me see. Let me see if I can do this. I'm going to try to go ahead and assign you guys. All right, so who all do I need to assign? I need to assign Mr. Mathis. I need to assign Jordan. And I need to assign Julie Park. Anyone else I need to send? Is there anyone else with you guys?
That's it, Judge.
Let me see if this works. You've been invited to join the breakout rooms. Go ahead and accept that. All All right, look at that. I'm becoming an expert at this. I signed them the breakout rooms. Okay, that's great. All right, let's get to the next hearing. So the next hearing, I believe, is on Hampton and 12th versus DCAD. Is there anyone here on that case? It's a motion.
Yes, Your Honor. JD Hannigan for plaintiff.
Okay.
Your Honor, I'm here also. Lauren Cox on behalf of DCAD.
And when are y'all set for trial?
We're set in October 6th.
Okay.
And in our motion, Your Honor, so this property tax appeal, it concerns 7 retail properties and 5 or 6 parking lots. In the motion, we put for April. I just sent Lauren an email. In the past, this court has been gracious enough to usually give us a first continuance until December in previous years. And I think if we could get that, that would help a lot. We've just been thrown so far off schedule. Usually spring is a very busy time for us to meet with the district and get through these things. And everything's just been very crazy this year, Your Honor, for, as you know, for multiple reasons.
Yeah, let me just, you'll hear the same speech my interns have heard a number of times. And it's becoming even more serious as this pandemic goes on, which is I'm very worried about kind of the dockets of, I'm sure of my court, but all the district courts. We haven't been able to try any jury cases for quite some time. There's a proposal on the table for next year to eliminate all non-jury weeks, which is when I usually try these DCAD cases when they go to trial. And so if we move this case, my concern is that it may be, I don't know for sure, but it may be a year or 2 years before we can reach it, because once we start having to try jury cases, we're going to just be doing those back to back, and we may not have any jury weeks for next year. And so that doesn't mean that I wouldn't continue this, but I worry about, especially one of this complexity, if when we're going to be able to reach it, because you're always going to be behind. I always do jury cases and then non-jury cases on my docket. And the best analogy I've been giving, I'll let one of the interns do it because they've heard it so many times. So Sydney Helber, why don't you give the analogy I always give here?
Judge Hoffman likes to talk about, have y'all ever seen the show Grey's Anatomy?
Absolutely.
Yeah.
Okay.
Well, he likes to say that it's like in the emergency room when it's kind of quiet and there's no one really there, but you know that it's coming. You know that something's coming. You get the call and no one's there yet. That's kind of what he thinks is going to happen with all of the jury trials just rushing in.
It's good job, Ms. Helbert. So my concern is that once I start trying jury cases, it's going to be a long time before we can get back to the non-juries. And so if you want a reasonable chance of trying this in any time soon, I really doubt we're going to be back to jury trials. You said it's set for October 15th. Is that right?
Correct, Your Honor.
I mean, it's possible we could be back to jury trials, but with the way the pandemic is going, I find that unlikely. So I would recommend you maybe keep it on the 15th and just kind of maybe reapproach me, the week before, and we can maybe talk about it. I worry that, when we're going to be able to get to you if we move you guys at all.
I completely understand. I know this court, you're a big advocate for the jury trial system and trials in general. I will say this though, this particular case, we've handled probably every year for the past 7 or 8 years. It's never gone to trial or even gotten close to trial. It has a couple times approached to where the two sides need expert witnesses. And that's kind of where my concern lies with this is it's going to take a little bit of time to get experts in order, and I want to explore the settlement further. And I realize that we shouldn't be using your time for settlement, but it's kind of we're in uncharted territory here. So if we could even get those 2 months, I think that would help a lot, because otherwise we're looking at expert deadlines in like 3 weeks based on moving the scheduling stuff back.
So you're wanting me to reset you. Let me kind of look at so the end of December then, is that the idea?
Yes, Your Honor. Lauren,
Uh,
is that okay with you?
Yes, we're amenable to that.
So December 29th?
That would be fine, Your Honor.
Yeah, I can't imagine we'll have juries that week. Just we might have juries before then, but I don't see us eliminating non-jury weeks this year. So yeah, December 29th is okay. So Rhonda, go ahead and reset this for trial on December 29th. And just be aware that, I mean, on all your cases, I don't know, Mr. Hannigan, if you've been in my court recently, I'm doing this on all my non-juries, especially my DCADs. It's just, I'm very worried about what's coming on these jury trials. And so just be aware that I'm being stricter than I have in the past about continuing these cases. But, you know, doing it on December 29th is really not a bad idea. And I don't think that's going to be a jury week anyway, even if we have jury trials back. So, all right. Anything else, guys?
That's it, Your Honor. I appreciate it.
Okay, great. You guys are excused. You guys be safe.
Thank you, Ms. Hilbert, for the analogy. I appreciate it.
Good job, Ms. Elbert.
Thank you. Bye.
Mr. Townsend, you've been here for quite a while. Did I miss you? Are you here for a case, or what? Are you just here to watch?
Yeah, thank you, Judge. I think we were called for a docket call. I think technically we're set for trial tomorrow, I think.
Okay. And yours was for a docket call? What do you mean?
I think so. Yeah, well, that's what I'm in with my paralegal's office, and she said she believes we have a trial setting tomorrow, but we were informed a docket call for that case today. So that's why I've been on hold. So
Is that, you mean for a motion for continuance? Is that it?
I think it's for the trial.
I'm going to show you my schedule for today, and maybe you can identify the case. I'm not disagreeing with you, but I'm not sure. I'm going to share a screen. Are you able to see that okay, Mr. Townsend?
Yeah.
Okay, I'm going to go ahead and share screen right now. Yeah, Rhonda doesn't know. She just texted me. She doesn't know what isn't sure what you're talking about. So let me go ahead and share screen, and you can tell me which case. I'm just can you see that okay?
Yeah,
Mr. Townsend, so do you see your case on here anywhere?
I do not.
I'm going to keep going. Just tell me if you see it. This is our dismissal docket. Are you maybe on the Hulbert case?
No, it's the Garbabi case. It's 19-02026.
Is it a jury or non-jury?
I think it's jury.
Let me do this. I'm going to go ahead and reopen this up, and I'm going to just kind of see if it's on the docket for tomorrow.
Okay.
And if you see it, I'm just going to go through this a little bit quickly. I don't see Galbabi here. Galbabi, I don't see it.
H-A-R. It's G-H-A-R-B-A-V-I. Garbabi.
There it is. Is this it right here?
That's it.
All right. So maybe there was something lost in translation, but you guys are supposed to be here tomorrow at 9 o'clock. I apologize. You've been on here for a while. I assume we just get to you. You're not going to trial tomorrow since it's a jury case. We're going to reset it. But I kind of talk with everyone about when you want to reset it, talk about different options, that kind of stuff. And so
Sure.
I'd encourage you to talk to opposing counsel about, different options that you guys might be willing to agree to, a 6-person jury, maybe a Zoom trial. We're going to be really backed up, and there are no good solutions here, unfortunately. So we're going to try to get.
To refresh your memory, the lawyer for the defendant, he was a no-show for the last hearing, and the judge cut him some slack, and he did agree to a 6-person jury. So we've
We
got
did,
that.
okay.
Yeah.
Right. I didn't recall that, but I appreciate you telling me that. So
Sure.
that'll increase the chances that we might be able to reach you guys this year, but who knows? So let's hope things start to get better with this pandemic. So, but yeah, you will need to show up tomorrow, and we'll just need to talk about dates on when we want to reset this.
Okay, Judge.
Okay, sorry for the inconvenience.
Hey, Judge, can I compliment you on something?
What's that?
Your father was Leonard Hoffman, right?
He was not. I get asked that quite a bit, but no relation.
Oh, I always thought you were his son because
Every attorney over the age of 60, I think, thinks that, but no relation.
well, you've had the same temperament that he does, and I wanted to compliment you on that. But even if you're not related, you have a nice temperament.
Oh, well, thank you so much. I really appreciate that, sir.
Fair enough. I'll be on the call tomorrow then.
All right. We'll see you tomorrow. Okay.
Sure, thank you.
All right. Bye-bye.
You just wasted 2 hours there.
Yes, I did.
Dave, do you know anything?
Mr. Gonzalez, what are you here for, sir?
Your Honor, I'm here for the Holbert motion for summary judgment at 10:30.
Okay, it's 10:30 now. Are both sides here for that?
Yes, Judge.
Mr. Hicks, are you there? Are you here for the other side?
I am, Your Honor.
Okay. We're on YouTube, but you guys want a court reporter as well?
I don't think we need one for motion for summary judgment.
We don't usually, but just I always want to give you the option.
I appreciate that.
And Your Honor, and Mr. Hicks, we're taking up, I think, kind of also your motion to strike as well, correct? Sean?
Correct.
Okay.
Correct.
All right, let's start with the motion to strike then.
Your Honor, the motion to strike is part of plaintiff's response that we received on July 20th. And again, Your Honor, this is Sean Hicks for the defendant, Eagle Systems. With the summary judgment response, the plaintiff included an affidavit of a Dr. Robert Rose. He had not been designated before filing the response. Now, with the response, or around the same time, the plaintiff designated experts. We have an objection as part of our motion for summary judgment as to the reliability of his testimony and his qualifications, but the motion to strike just deals with the untimely designation. We were operating under the rules in this case. We tried to get a scheduling order in place, but that never happened. And so because of, under the rules, the expert designation deadline would have been, I believe it was July 3rd. So it was about 17 days late. It was also on the eve of our motion for summary judgment hearing, which creates a little bit of surprise. Now, my argument will be that the testimony really doesn't create an issue, but I still think it's untimely. I still think it's late. And so that's the basis for our motion to strike.
Okay, response?
Your Honor, if I may, we did file an amended motion for leave, Your Honor, and reply in response to their motion to strike. It is fairly straightforward. It is verified by myself. Quite frankly, I dropped the ball. It was not conscious indifference at all. It was an error on my part. I attached the email back and forth, and quite frankly, Your Honor, I thought I had replied like I usually do to those types of proposed agreed scheduling orders. Agreed, signed with my permission. In fact, when I saw their motion to strike, I immediately searched my inbox and sent file and verified that I had not sent that email, mistakenly had not replied or responded to their email. It is a 13-day deficit, Your Honor, or 17-day rather, I'm sorry. I don't believe there is a prejudice to allowing them an extra month or even 2 months to designate a response expert. We have a December 1st trial setting in this case. I do not believe if they need more time for that to find and designate a rebuttal expert, of course, we would not be opposed to that. We do, like I said, Your Honor, we do have on file for Your Honor to view a response a motion for leave in response to their motion to strike that lays all that out on the record. And again, I take full responsibility for not timely designating. I believe there's, in essence, no harm, no foul. It was a clerical error. It was a matter of a few weeks late, and I don't believe defendant would be prejudiced in any way, shape, or form to allow the designation and therefore allow them more time to designate a rebuttal expert, Your Honor. Your Honor. Sean, did everybody else freeze or just me?
Judge Hoffman disconnected. He'll be right back.
Okay. Your Honor, I cannot hear you.
Can you hear me now?
Yes, Your Honor.
Okay, I apologize. There was some kind of, it sounded like an explosion, and I don't know what it was, but the power went out for a second. So I don't know, it's some maybe an electrical explosion. So I'm having to call in from my cell phone while I try things here. So sorry about that. Okay.
Your Honor, if I can ask, when did you cut out when I was?
All right, sorry, I apologize. I heard just the very end of your discussion about. So, all right, are you guys? Let me see if this is working now. Okay, all right, so I can get off of this. Let me see if I can. All right. Okay, can y'all? All right, everyone hear me okay?
Yes,
Yes, Your Honor.
I can.
Okay, sorry about that. Let's go ahead and get started.
So, Your Honor, where did you cut out when I was giving my argument on the motion for leave and response to the motion to strike, if I may ask, so I don't repeat myself?
Just that you had said that you were okay with them getting extra time.
Yeah, yes, Your Honor, exactly. And I take full responsibility for missing it. It was, like I said, just to be clear, there is a signed verification. In our plaintiff's motion for summary judgment, electronic hearing notebook number 7 that was submitted to the court and bookmarked is our first amended motion for leave to designate in response to their motion to strike. It lays it all out, like I've said, more time, even if they needed a short continuance on a December 1st trial setting, of course, we would be unopposed. If you know, given what the ruling is on the motion for summary judgment today, Your Honor.
Okay. Mr. Hicks?
No further response, Your Honor.
All right, so I'm inclined to give, people make mistakes, and I'm inclined to give them some extra time. But I also think you shouldn't pay the penalty. So if you want to reset the summary judgment and get a new expert or whatever you want to do, I'm okay with that. Or if you're ready to go forward today, I'm also okay with that.
I'm ready to go forward, Judge. I don't think the testimony of Dr. Rose has any impact on our motion. So I'm prepared to move forward.
Okay. Go ahead.
All right, Your Honor. Again, this is Sean Hicks on behalf of Eagle Systems. We're here on my client, defendant Eagle Systems, motion for traditional summary judgment. The incident that this all arises from is a tragic one. In February of 2018, a gentleman by the name of Marlon Smith walked into the leasing office of the North End Apartments, not too far from the courthouse. He walked into the manager's office where Nancy Churchwell was. The extent of their conversation is unknown, but Mr. Smith pulled a gun and shot her 9 times, killing Ms. Churchwell. As he fled the leasing office, he did not attack or shoot any of the other employees that were within feet of him in the leasing office. It appeared that this was a targeted shooting against Ms. Churchwell. Mr. Smith ultimately fled and was killed in a shootout with the police. Now, the question is, who is Mr. Smith? Mr. Smith was a former employee of my client, Eagle Systems. Eagle Systems provided, by contract, nighttime guards to man the front gate at night, the gate where the cars come in and out. That was the extent of their duties on the premises. It was just during the nighttime hours. Now, this incident occurred around 10 a.m. In the morning when my client is neither.
You cut out for a second there. What did you say?
What was the last thing you heard?
Are you still there? Okay, great. Are we frozen?
You're frozen. I can see you.
Okay, I can hear you now. All right, so maybe I was frozen.
Okay. I'm sorry, Judge. What was the last thing you heard?
You were describing who Mr. Schmidt was.
Got it. So Mr.
And I've already read everything. He's a former security guard, I guess, that there were some concerns about his mental status, I guess, and their argument is that you guys didn't inform them about these concerns before he got, or after he got fired.
Perfect, Judge. So I can fast forward a bit. The key important point is we terminated Marlon Smith 6 months before this incident. There was an interaction at the time of his firing with our HR rep, Ms. Springman.
Mr. Hicks, and I may have missed this in the record, is there anything about, I know that he said some really kind of disturbing things, but did he ever say anything involving the plaintiff or her employer, or was that the only place that he worked for the company, or did he work a lot of other places?
Sure, he only worked at the complex.
Right.
The conversation he had with Ms. Springman that the plaintiff is relying on here did not involve any threats made to really anyone other than Ms. Springman. And her testimony was she didn't fear for her physical safety. But again, this was 6 months before this incident. So for 6 months after this incident, my client had no control over Mr. Smith. He was pretty much his own person out in the world. We also had no control over the premises when this incident happened. So to cut to the chase, Judge, I think
aren't they kind of arguing that you guys had a fiduciary duty to inform them about the potential threat posed by your former security guard?
Sure, and that is the argument. The case law that we cite, I think, is directly on point. The Banzaf case is the first one, which, Your Honor, I don't know if you've had a chance to review the cases that I included in my binder, but I'm happy to talk briefly about them because I think
I might have that. Let me see. Nope. Okay. No, I don't have that. I don't think. No, I don't have those. Okay, go ahead and share screen them.
See if I can. Bear with me, Judge. I apologize.
Oh, did I enable that? Let me see. Yeah, it's enabled.
Yeah, I'm having some computer freezing issues at the moment. Judge, if it makes it easier, I have in our reply brief that you should have, we talk in detail about both of the cases I'm going to talk about because I'm having trouble here.
Okay, the reply brief. Yeah, I can pull that out.
Okay. Maybe I got it here. Actually, I think I just figured it out here. But if you've got the reply brief, we can go off that. So the first case, Judge, is the Banzaf case that we talk about in the first part of our argument there under the first subheading. And this was a 2009 case. What's important here is that what happened here was a couple of employees that worked at a sporting goods store were working one day when someone came in, robbed the store, and shot and killed them. The claim at issue was against the security company ADT. The argument that the plaintiffs made were the same argument that the plaintiffs make here, that there was a contract between ADT and the premises that created a contractual duty of care, and that also there were extra contractual duties created both by the contract and common law. What the evidence showed there was that the ADT alarm system was only to be on or activated during non-business hours when no employees were there. That's similar to our case where we've got a security company that's only there at the nighttime hours, not when this incident occurred.
But that's not the same situation we have here, because in that case, they're saying they should have had someone there. I think the claim in this case is that you guys should have warned them about the danger posed by their former security guard, not that you should have provided security during the daytime when, to the extent that they're making that claim, I agree with you, that should be granted summary judgment. But I thought this was a duty to warn case.
Well, the plaintiff's response really raises two issues. Number one is the contractual duty of care. And that's what Banzaf talks about, that, listen, the defendant's duty is limited to their contract. Their contract was nighttime security at the gate. That's pretty much it. So I think that argument is out the window. The duty.
All right, I'll grant summary judgment on that issue.
Okay. Now the next issue is the duty to warn. The Dallas case that we cite, it's Gatton versus McCarley. We start talking about that on page 4 of our reply. And this deals directly with the duty to warn. This is a 2013 Dallas case. Procedurally, it's a little weird where it was an appeal off a motion to dismiss, I believe. And what happened here was the defendants were hosting a party at their house. One of the invitees was someone that they were related to and also lived on the premises. Prior to the plaintiffs showing up, the assailant, we'll call him, told the hosts of the party, hey, I'm going to pick a fight with the plaintiff's husband when he arrives at the party. The plaintiff and the husband arrive. Apparently there was another altercation before they arrived between the assailant and somebody else at the party. The plaintiff and her husband arrive. As the individual said he was going to do, he started a fight with the plaintiff's husband. The plaintiff was ultimately injured in that fight. And the same arguments in that case are being made here, that there was a duty to warn given their knowledge. What the court relied on and talked about first off was the right to control. In that situation, the homeowners had no right to control the actions of the third party. That's similar to what we're dealing with here. Not only did my client have no control over the premises, they had no control.
But you, as a host of a party, you don't have a fiduciary duty to a guest, right?
Right. But
in this case, they're arguing that there was a fiduciary duty existed between, as the security company, they had a fiduciary duty to their client. Wouldn't that kind of distinguish this case?
I don't believe it does, Judge, especially when you go back to Van Zaff, which you're talking about security companies and their duty only being limited to the contract. And that was the issue in Van Zaff that the plaintiffs tried to raise. They said to the court that, listen, we've got a security company here. They owe duties because of the contract and separate from the contract, including potential special relationships or fiduciary duties. But that is not, that's not what we have here, or that's essentially what we have here. We have a contract that determines the scope of the duty. That's it. The contract does not cover this particular situation, so there's no duty. And to take it further with, okay, is there a duty to warn? Well, the case law makes clear that there's not, because we don't have any control. We have, because again, we're talking 6 months between when we fired Mr. Smith and this incident happened. And the real question becomes, what were we supposed to tell them in the first place? We did tell the complex he had been fired, that he refused to take a drug test, that his family had apparently left him and he wasn't in a good place. All of that information had been conveyed to the complex. So much so that in the days and weeks leading up to the incident, when Mr. Smith made multiple visits to the complex, Ms. Churchwell instructed employees he's not supposed to be here. And they brought in courtesy officers, the police officers that live on site. They brought them in and advised them of the situation. So this isn't first off, there were no threats made to Ms. Churchwell that we were supposed to advise them of. But regardless, we passed along information. They acted on that information. They just didn't act well enough, I guess. But that's not on my client. And so,
Your Honor, let me just make clear, Your Honor, we believe, given your ruling at this point regarding the contractual obligations or lack thereof, this is a negligence case. It's not even a negligent security case. It is based upon the theory of liability as reflected by our latest First Amendment petition is based on negligence. The only question I believe that the court needs to answer today was there a special relationship between Nancy Churchwell and or her employer North End and Eagle Systems? And the answer to that is yes. There was a fiduciary duty and there was an ongoing relationship up until the point.
But didn't they satisfy their fiduciary duty by informing you of what they knew, or is there something that they didn't? Is there any evidence or something they knew that they didn't inform you about?
That I was going to say, I will respectfully disagree with counsel about what the record reflects. The two co-workers of Nancy Churchwell that were deposed, which are referenced in our response, make clear they did not understand that there was a potential for physical violence on the part of Mr. Smith, nor to their knowledge was that ever related to them or Nancy Churchwell by Eagle. And let me be clear about this. When I say it's not a negligent security case, it's not a negligence premises case, it is a negligence case. And it doesn't matter, I don't believe, Your Honor, whether it was Eagle Systems Security, Eagle Systems Lawn Maintenance, Eagle Systems Cleaning Services, Eagle Systems Vending Machine Services, for example. They just happened to be a security company that knew of a danger when Mr. Smith told their HR person that she better watch her back and then use an expletive. When he was fired 6 months before, they failed to relate how that violent comment to Ms. Churchwell, and none of her coworkers were aware of that. Then, when Mr. Smith showed up 13 days prior to the date of incident, the unfortunate tragic death of Ms. Churchwell, wearing security garb, Your Honor, and she relates that to them, and she notes that he's disheveled, they again do not tell her, hey, he fell off the deep end. He made this physical threat to our HR person. And there's testimony from her coworker, Ms. Pritchett, that had they known about that physical threat, they would have immediately called 911, immediately called the courtesy officer on site. Those are all fact questions, Your Honor. However, I begin to back it up in the 1,000-foot view. The only question I believe before the court in order to determine the traditional motion for summary judgment is whether there was a special relationship between Nancy, her employer, North End, and Eagle. And I think resoundingly the answer is absolutely yes. And it is a fact question as to whether or not Eagle acted reasonably given their information they had, and given that the record is clear that they did not relate in its totality all the information that they had about Marlon Smith to their ongoing customer, to the extent that that her coworkers are on the record as saying they would have done essentially things differently had they known about Marlon Smith what they know now. And again, this is not a determination as a matter of law of what a reasonable company in the same or similar situation that Eagle should have done. It's just whether or not there's a fact question. And I think there's absolutely a fact question. Regarding Catan, Your Honor, the one case on point about creation of a dangerous condition or a failure to warn, at page 676 of that case, and I want to disagree about what they knew or didn't know about the propensity for violence in the relationship. Let me back up. All the cases they cite in the reply brief, Your Honor, are distinguishable on two bases. First, the victims had no prior relationship with the alleged tortfeasor. In Banzif, the persons that suffered injury did not have a relationship with ADT. That is obviously not the case here. In Catan, and also in that case, they had no prior knowledge of a threat of physical violence. Again, easily distinguishable here. There is a relationship and was a relationship prior to the shooting between Nancy and the defendant. And the defendant knew that there were at least violent tendencies or violence had been talked about by the shooter, and they did not relate those threats. In fact, Nancy Churchwell in emails to Eagle indicates that up until the point of his firing, she thought Marlon Smith was a model security guard. She would compare other security guards to him and say, I'll get Marlon to train the new guy. Going to the point, Your Honor, that goes to the point that Nancy Smith had no inkling of the violence that was about to be perpetrated upon her because she liked Marlon. Even though he showed up 13 days before, maybe disheveled, but wearing his old security company garb, I'm going to argue she felt bad for him. I don't know. But to get to the point, Your Honor, the Catan case, the pleadings.
I don't need any more argument. I'm going to go ahead and grant the summary judgment in part, deny the summary judgment in part. Deny it on the motion on the duty to warn, granted on the contractual provisions to provide security, they had a duty to provide security that day. So go ahead and get me an order on that. Anything else, guys, today?
Yeah, two things, Judge. May I, and I understand, and if the court insists, I will not make the argument, but I had one other point of argument I wanted to bring up on this issue that I think is very important to your decision.
Okay.
If the court will oblige. And I will try and share the screen here because this is a case that's cited in the plaintiff's response. And it talks about fiduciary duties. And what it says is, and it was a similar situation where you have a contract and a question of whether or not fiduciary duties exist. And the case, which cites Texas Supreme Court case law, makes clear that informal fiduciary duties are not owed in business transaction unless the special relationship of trust and confidence existed prior to and apart from the transaction at issue. That's what we have here. We have a contract that did not exist until the contract was entered into. And there's no fiduciary duty in that situation because the duty is limited to the contract itself. And I understand we got a little bit down the line with regard to what's reasonable and what's not, but the initial question is whether there's a duty to warn. And nothing that the plaintiff cites to, no legal authority, creates that duty to warn. In fact, all of the case law that's been cited, even the cases that the plaintiff cites to, suggest that or make clear that there isn't a fiduciary duty.
Are there any cases cited by either side that says a security company owes a fiduciary duty?
Your Honor, Your Honor, I think, again, we're muddying the waters. Whether or not there's a fiduciary duty, there is a special relationship. And even what he quotes right here, Your Honor, is distinguishable because the transaction at issue is the shooting. Prior to the shooting, there was a special relationship between, unfortunately, Nancy Churchwell and Eagle. That is a special relationship that we believe controls. That there was a contract or not is really besides the point. There was, but the issue, I believe, that where the fact question lies is because of that special relationship that pre-existed the unfortunate shooting of Nancy Churchwell, did Eagle act reasonably? Yes or no? And that's a fact question, Your Honor. And Your Honor, if I may, the one thing I wanted to mention about Gatan that they cite regarding the negligence question only, the record of Gatan says the wording of in Gatan at 676, the pleadings do not indicate that appellees learned of Rosser's threat prior to inviting Gatan to the party at their home. I just want to point that out because that's why that's distinguishable. The record there, the unfortunate defendants in that instance had no idea apparently of the threat prior to inviting Gatan. Here, that is distinguishable, Your Honor. But going back to Your Honor's question about the informal fiduciary relationship created, I think, again, there can be a general duty that is created because of the special relationship. And that's what the case law bears out. Because there's a contract does not negate that special relationship, Your Honor. It becomes just a basic, how would a reasonable company in a same or similar circumstance, would a reasonable company react? What would they have done or not done in same or similar circumstances, Your Honor?
Okay, that kind of undercuts your whole argument.
Well, Your Honor, let me say this. Going back to the fiduciary
So you're admitting that the security company had no fiduciary duty to the apartment complex?
No, absolutely not, Your Honor. Absolutely not. There was a contractual relationship. And I'm sorry, Your Honor.
Is there a fiduciary duty?
I believe there is by virtue of the contract and by virtue of that, the own testimony from Mr. Carrington, their head of security, testified that in the past with other clients, he had advised them to increase their security based on different factors to other clients. They failed to do that in this circumstance, and they were wholly able to do so under the contract. There absolutely is. I'm sorry, Your Honor, I did not mean to make it seem there was no fiduciary duty. There absolutely was a fiduciary duty based in contract. And that's why Your Honor kind of ruled on that midway through opposing counsel's argument. I believe there's a fact question whether or not they breached that contractual duty under the terms of the contract. That's why I would urge the court to deny not only as to the basic negligence under special relationship that developed, but also under the fiduciary contractual relationship that existed. Nancy Churchwell was the one that signed the contract on behalf of North End with Eagle, Your Honor. That's how much that fiduciary duty existed, not only between Eagle and her employer, but Nancy Churchwell as a representative for her employer. So I absolutely believe there was a fiduciary duty. I believe that's a fact issue again for the jury, Your Honor.
Okay, so just so it's clear, I'm denying on the duty to warn, and that and I think we'll have to look at, if it gets down to this, it goes to trial, then we'd have to look at, does a fiduciary duty exist? And then there's certain duties in that situation. Does there a contractual duty to warn? But as to the issue of whether or not they had a contractual duty to provide security on the day of the accident, I'm going to grant the summary judgment. All right, guys, I got to get to my next hearing. Okay, so you guys have a good day. All right.
May we be excused, Your Honor.
Yeah, just go ahead and email an order to my court coordinator, Rhonda Pinson, that reflects my rulings, and try to exchange it with each other and try to get it to the court by Thursday.
Thank you, Judge.
Thank you,
guys. You have a good day.
Judge, we're back from the breakout room in case you were not informed.
All right. Yeah, I saw you guys. Have you guys reached an agreement on everything?
Not everything. Most of them they've agreed to supplement. We have 4 to address with the court.
Okay. Go ahead.
The first one, Judge, is interrogatory number 4. Actually, I believe it's part 4H. Part 4H addresses for any bank account which any business that you own or operate has, state the name and address, the account number, and the balance. In the answers given, the response was, I have a trust account set up. Let me just share my screen. Give me 1 second. I'll let you look at it rather than read it to you. Can you see that?
I cannot.
Oh, let me click share. Okay, so right here, Mr. Gilbert admits to having a trust account for payments to suppliers, vendors, and subcontractors.
You're still not, okay, there you are.
But this account hasn't been disclosed. There's no information about the account. No documents from the account have been produced. And so I believe that my client's entitled to more information about this account and any other accounts that he has.
I would agree with that.
Response, and so I believe that Your Honor should order them to produce the information about that account.
So ordered.
Okay.
What else?
The next one, Judge, is number 5 of the interrogatories. Number 5, if I can take you back to the actual verbiage of the interrogatory.
Wait, hold on a second, Jordan. Your Honor, I'm sorry I was muted there and I was trying to talk and I couldn't figure out how to do it. My concern about that 4H is not the disclosure of the account. It is whether or not he will agree not to run out and try to garnish an account that has somebody else's money in it. If my understanding is he has a trust account for people that he's doing remodeling work for, and they put money in there for him to pay subcontractors. So I don't want to wake up one day and he's shut down his ability to earn a living and to do his work because he's garnished account that doesn't even belong to him. So if he'll just agree or if he'll order that, I think that'll solve the problem.
Judge, that's both not before the court today, nor is it within my power to make an agreement about something like that without consulting with my client.
Well, none of this is before the court today.
You've already made an order that they need to give us information about the account. There was no objection. As far as the account goes, I think that part's settled, if I may move on.
Mr. Mathis, I agree. That's a fight for another day. So I'm going to go ahead and order 4H.
Okay, the next one, Judge, is number 5. Number 5, if I can go back up to the interrogatory, asks Mr. Gilbert to identify jobs and contracts awarded to you relating to services or products you provided or will provide for compensation from and after January 1st, 2014 to the present, effectively asking him to disclose how he's earning a living. We know he's a general contractor because this case is almost 8 years old at this point. We know he's still operating as a general contractor. And so this interrogatory asks him, tell us what houses you're working on, what companies you're working for, what jobs you're working for. And the response is, I have been a general contractor in the Park Cities neighborhood, and I have completed work on certain streets.
And I said we would agree to that.
Okay. Go ahead. It's so ordered.
Okay. The next one is number 7, Judge. I'll go back to the actual interrogatory for you. Number 7 asks for identify each item and state the estimated value in which you have an ownership interest. The problem that I have with the answer is that it is not specific about what the personal property is. Number 7, which I'll highlight here.
It also doesn't say what's exempted, so you're going to need to answer that as well.
Right. Thank you, Judge. Then the last one that we have to address is number 25, which goes along the same lines. It's identify the brand, make, and model, purchase price, and fair market value at this time of all personal property you have in your possession. It's sort of the same answer as before.
So ordered. Anything else?
That's it for now, Judge. We have a bunch of stuff that they've agreed to supplement. So for now, I'll just pass the rest of it without prejudice to coming back here, and hopefully we don't have to.
Go ahead and get me an order on that. Email it to my court coordinator, and you guys have a great day, okay?
Will do, Judge. Thank you very much.
You guys. Okay. Are both sides here for the next hearing?
Your Honor, is the next one the TRO? Not sure which one the next one is.
Let me look it up just real quick. My clerk gave me a lot of hearings today. This has been a busy morning. So did I already talk to International Offset Corporation versus 4G Corporation?
No, Your Honor, that's Charmaine Voorhees-Becken speaking here on behalf of the plaintiffs. We have not addressed that case just yet.
Okay.
I'm ready to proceed if you are.
Somebody else is coming in. I want to make sure I'm not missing. Do you expect the other side to be here for that?
I do not, Your Honor. We're trying to serve
Okay.
the defendants.
Miss Broussard, what are you here for? You're muted, ma'am.
Your Honor, she's here for the TRO, same as me.
Okay, that's fine. All right, Ms. Becken, you may proceed.
Good morning, Your Honor. Charmaine Voorhees-Becken here on behalf of Plaintiffs International Offset Corporation and Artists Corporate Trade LLC. We filed our motion for substitute service, trying to get service on all 5 defendants. And those are 2 corporate entities, 3 individuals. And we've determined that the best address for service to provide notice of this lawsuit would be the principal office, which we've confirmed is the leased office space for the entities, and it's also the place of business for the individuals. And we've got that in our Exhibit A, which is our affidavit of the process server.
Is this the case? Let me just, I'm sorry, I need to look at this again. Do we know that they're still working at that location though?
Well, Your Honor, the last time that I do believe the answer is yes. And the Exhibit A to our motion process server went by 4 different times, and on 2 different occasions, 2 different receptionists confirmed that they had seen the gentleman there at the office February, and then as recently as May. Of course, we filed our motion back in June. So that's the most recent information we have. We do believe they're still working there.
So the affidavit says, I attempted delivery on 6/12/2020, was told by a different receptionist of the workspace that she had not seen any of the men since February, and there had been an unpaid bill with the space. And then I guess the 6/3 receptionist said that she had not seen any of the men since she started working at the suite a month ago, but they did have a space. I asked for an address or working number she might have on file for any of them. She said that she had no address. That is the phone number I had found for NutraSpace. It is not a good working number at this time. Is this what's the address listed in this by the Secretary of State, or how did you get this address?
So in our original petition, there's Exhibit A. This is a breach of contract matter. And in Exhibit A, for 4G Holdings Corporation, they signed Roy Varghese as president, and they listed this 5080 Spectrum Drive address.
Okay, but is it the okay? Okay, maybe I'm misunderstanding the facts here. Then let me look at this again. And I'm going to try to share screen this just so we're on the same page.
Sure.
So this is the one you're asking for, right?
Right, that's correct.
And then you're trying to sue 4 individuals, is that correct?
So it's 3 individuals, and those are it's a principal director of the 2 defendant corporate entities. And so I'm sorry.
Yeah. Go ahead, sorry.
So for 4G and NutraSpace, Roy Varghese, defendant Roy Varghese is the president of those two entities. And so we're trying to serve the corporations through their president.
Okay. But do either of those corporations have an address with the Secretary of State?
Well, NutraSpace has a certificate of revocation and no registered agent listed.
Okay.
And for 4G, best information we can find is also that it was revoked. It's a Nevada corporation and it was revoked. And I do not see a registered agent. And they have not filed in Texas.
Okay, so, all right, so Mr. Beckett, I'm a little worried. I can go ahead and grant this as the two corporations, I guess. You said that, well, you said that the address for 4G listed this, but what about for NutraSpace? How is it NutraSpace connected to this address?
So because we're trying to serve NutraSpace through its president, Roy Varghese,
Okay.
and that affidavit that you have on the share screen, I believe on the June 3rd attempt, the process server was able to confirm that NutraSpace does have a leased space at that 5080 Spectrum address. And so for those two reasons, that's why I believe the 5080 address would also be a reasonably effective way to provide NutraSpace with notice of the suit.
All right, I'm going to go ahead and grant the motion for substitute service as to the two corporations. I don't think you have anything to link the three individuals to this location, or not enough at least. And so I'm going to deny it as to the individuals, but I'll allow it to the corporations. If you really want the default judgment to hold, you might want to do a little bit more research here if you're looking at a default judgment eventually. But I'll go ahead and give it to you now, but reluctantly. So just, you might want to think about or talk to some other folks there at your firm about, is this what you want to do as the corporations? For the three individuals, you just need to find a better addresses.
Understood.
What do you want to do at this point?
I'm happy to, I guess, would it be better if I provided the court with maybe additional, do you need an amended affidavit, or I'm happy
I guess, for the corporations, that's maybe all you can do. I can't think off the top of my head. If you've looked at the Secretary of State and you've looked through, I guess, whatever documents you have involving the contractual relationship involving these two corporations, I'm not sure what else you can do, but you might want to think about it. For the three individuals, you'll have to do some kind of skip search or something for them to try to find them individually before I would grant a subservice on this.
Understood, Your Honor.
All right. Well, thank you, Ms. Becken. I'm going to go ahead and take a brief break, guys. I haven't had a break all morning. And then Mr. Wood, is your opposing counsel here?
Yes, Your Honor.
Okay. All right.
Yes, Your Honor, it's me.
Okay. I'll be there in a second. Okay. I'm going to stop video and I'll be right back.
Good morning, Robert.
Hey, Marguerite. How are you doing?
I'm doing good. How about yourself?
Good. Got a big audience today.
Got a big what?
Audience.
Yeah, we do.
Okay, guys. Are you all ready for the TRO?
Yes, Your Honor.
Yes, Your Honor.
All right, let's go ahead and proceed.
Your Honor, I'm Marguerite Broussard. I'm here for the plaintiff, Lone Star Solar Screens. We are a company that has sold exterior solar screens since 1992. Exhibit 1A of the TRO provides some examples of what they look like. They go on the outside of the house. They're made of different types of fabric, different levels of shade. We install them in residences. And in recent years, we've expanded into the commercial market, and we do large jobs at apartment complexes and office buildings. This is a non-compete situation in a trade secret non-disclosure situation. We're here because we have two former employees, Jose T. Garcia and Eduardo Reyes, who signed non-competes with Lone Star in 2013. And the non-compete is 2 years from the date they leave employment. Within that 2-year period, they have both gone to work for a competitor, which is Solar Screens and More. Defendant Edgar Moraz does business. He's a sole proprietorship as Solar Screens and More. And they are a competitor of Lone Star. They sell exterior solar screens throughout the Dallas-Fort Worth Metroplex. Attached to our TRO application as Exhibit 2C is a website screenshots of showing that they do sell the same thing we do. Edgar Moraz was a former Lone Star employee who knows about these non-competes because he signed an identical one in 2013 as well. He was a former manager, and Lone Star in 2018 had to get a TRO against him because he left the company and opened up his own competing business, went after our biggest corporate customers. So he knows we had these non-competes, and despite that, he's hired two of our employees who are bound by these non-competes. The reason this matters to us is there are, and the issues are slightly different between Jose Garcia and Eduardo Reyes. With Jose Garcia, he is a longtime screen builder, and Lone Star has a proprietary method for building solar screens. And I won't get into specifics because this is public, but most solar screen companies send patterns out for solar screen manufacturing. We don't use that method. We use a very special measurement method that allows for our products to be more accurately built, better quality built, and installed better than other people. Jose Garcia has this information, and given that he's worked for Lone Star as a builder since 2008, he's going to use that information for Edgar Moraz. Edgar was he started out as a builder, but he was not good at it. And having Jose work for him gives him a huge competitive advantage. With regard to Eduardo Reyes, Eduardo was an installer and a salesperson, and he knows how the measurement technique is applied to installations. And this matters because we do, unlike many solar screen companies, we do large scale installations where efficiency and accuracy is a big deal, because on a large scale project, if you make a measurement inaccuracy, that costs a lot of money, and it's a big error. Both Eddie and Jose have experience doing large scale solar screen installations at apartment complexes. In addition, as a salesman, Eduardo has knowledge of Lone Star's pricing and pricing structure, and the identity of our corporate customers. We don't think Jose Garcia knows the identity of our corporate structures, but having been on installations, he knows where they've been installed at, and knowing the address of an installation it is possible to do some research and find out who the owner is of that property, or who the management company is. And so for these reasons, we're asking for a restraining order. We're asking, number one, that Solar Screens and More not tortiously interfere with our contracts, not hire former Lone Star employees who are within the timeframe of their active non-compete periods. We're asking them not to use our trade secrets, including our special building technique, and use our customer information or our pricing information. We're asking that Mr. Reyes and Mr. Garcia be enjoined from working for a competitor until the terms of their non-competes are up. And we're asking that they not use or divulge Lone Star's trade secrets. And we're asking all three of them not to destroy their electronic records.
Response?
Your Honor, I represent Robert Wood for all the defendants. Your Honor, these agreements were signed January 2013. Mr. Reyes resigned from Lone Star in November 2014. Then he returned to the company. He resigned again November 2017. Mr. Garcia resigned from Lone Star February 14. Then he returned. He resigned again March 2014. Then he returned. He resigned again November 2017. And I've given Your Honor declarations signed by both my clients to back up what I'm saying. These resignations were real resignations. They weren't leaves of absence. They quit the jobs and they went to do other jobs. And in fact, in Garcia's case, he left March 2014 and didn't return until June 2015. And the reason it matters, Your Honor, is if you look at the restrictive covenants, it says they last for a period of 2 years after employees' voluntary or involuntary termination from the company. And so when Reyes resigned in November 2014, his restrictive covenant lasted until November 2016. When Garcia resigned in February 2014, his restrictive covenant lasted until February 2016. Their restrictive covenants ended years ago. And when they returned to Lone Star, they did not sign new non-competes. They were the only ones they'd ever signed were the ones they signed back in 2013. They didn't sign new non-competes, and they did nothing when they came back to reaffirm the new non-competes. And in the event that that Lone Star is going to say, well, it was implied that they continued under the old ones. The problem with that is the statute of frauds. The statute of frauds says that if an obligation cannot be performed in 1 year or less, it has to be in writing. The obligation here, the restrictive covenants here are 2 years long. That's something that has to be in writing. And again, those were expired 2 years after they left, which would have been back in 2016. These non-competes are gone. Second thing, Your Honor, is the businesses are very different. Lone Star is a solar screen company, and hopefully you can see the screen that I'm sharing with you, Your Honor. This is an example of a solar screen window. That's something that they do. Another example is right here. This is a solar screen window. We've all seen those. That's what they do. I want to show you what they don't do. They don't do patio enclosures. This is an example of a patio enclosure. Another thing they don't do are called roll down screens. That's right here. My client doesn't just do solar screens. My client does patio enclosures and roll down screens. So if Your Honor were going to enter a TRO today, I really don't think you should since their restrictive covenants expired years ago. But if you were going to enter a TRO today, I would say at most you would keep these individual defendants from doing doing solar screens. You wouldn't keep them from doing roll down screens and patio enclosures, which Ms. Broussard's clients doesn't even do. Last thing is this, Your Honor, this is not a sophisticated technical business. This is the solar screen business. These businesses are a dime a dozen, kind of like law firms. They're a dime a dozen. They're on every street corner. And, you know, Ms. Broussard says, well, there's something special about measuring and cutting screens. But Your Honor, most solar screens are either square or they're rectangular, and there's nothing special about that. The only time it ever gets tricky is if you have a solar screen like the one I'm showing you right now, which is arched. But even the vendors that you buy these things from, like this one right here, will show you in their catalog how to cut an arched solar screen. So there's nothing really super secret about it. Second thing is this, pricing. Your Honor, the truth is my client does not compete with Ms. Broussard's client on price. And the reason we don't is her client buys in bulk. Because they buy in bulk, their costs are lower and their prices are lower, and we cannot compete with them on price, and we don't try to. Customers don't come to us because we have lower prices. Customers come to us, quite frankly, because of the people who work for us. We're just good people. We're responsive. We get the job done. That's why people come to us, not because of price. The last thing is this, Your Honor. The solar screen business, if you think about it, these customers are one-off customers, right? You get these solar screens put on your home, and chances are that's the last time you ever call the solar screen company. Sometimes these projects will be split in half. Maybe you'll have the solar screen company out and put the screens on your front windows, and then 6 months or a year later, you'll call them back and have them put the screens on the back windows. But chances are you're going to call the same company to finish the project that you called to start it. The only reason you wouldn't do that is if they'd done a bad job for you. But for the most part, Your Honor, at least with respect to solar screens, our competition against them is for new customers that neither one of us have ever had. We're not trying to steal their old customers. They're really not stealable. We're just competing with them for new customers that neither one of us have ever had. Your Honor, just finish with 3 quick points. Number 1, the restrictive covenants have expired. Number 2, our business is different from theirs in 2 key areas, which means if you were going to do a non-compete or a TRO on the individuals, it ought to be limited to solar screens, not to the things that we do that Ms. Broussard's client doesn't do. And the last,
I got it, Mr. Wood.
Thank you, Your Honor.
Ms. Broussard, what is your response to those 3 points?
Yeah, Your Honor, the employees, Mr. Garcia and Mr. Reyes, did go on leave during seasonal times. They came back. They were continuously employed. Sometimes they may have gone to Mexico to visit family, but they were continuously employed at Lone Star. And it's our position that they did not terminate employment. They may have worked seasonally, but they came back and they were bound by the non-competes. We do roll down shades. Also, these are not one-off jobs. 30 to 40% of our business is repeat business. So it does matter to us, even the residential stuff.
I think someone's showing me on the screen, if you're really quitting, you probably should just turn your stuff in. Did they turn their stuff in?
Your Honor, yes. And the point is that this makes the point that I was making. This is not a leave of absence. He quit the job. He quit and he went to work somewhere else. It's not a leave of absence.
For which defendant?
That's for Mr. Reyes, but it was the same thing with Mr. Garcia. They quit. It wasn't a leave of absence.
Right. How do you reconcile this text here, Ms. Broussard, for Mr. Reyes?
Let's see, it was in November. So it was during the winter time when he went to work for a family business. He wouldn't have needed his equipment if he was going to go work with his family business over the winter time. And then he came back, so from Lone Star's perspective, this was a leave.
I don't agree for Mr. Reyes based on this text. What about the other defendant? What do you have showing that it's quitting?
I don't have a text message like that, Your Honor, but I do have a sworn declaration from him saying that he quit and it wasn't a leave of absence. And of course, I mean, it seems like they would have treated them all the same. If they're going to treat Reyes as quitting, I think they would have treated Garcia the same. I think there's enough doubt here, Judge, for there not to be a TRO for the next 14 days. They can come into court 14 days from now and try to put it on for a TI hearing, but I think there's enough question today about whether this really was a leave of absence situation. I don't think it was.
Even if it wasn't, Your Honor, they're in possession of trade secrets and they're working for a competitor, and our exhibits show we have attached to our TRO app as exhibits.
How much of a
1B and
gap
1C.
was there for this other defendant between when he left and when he came back in 2017?
Are you talking about Garcia, Your Honor?
Not the one who didn't have the text message.
Garcia left in February 2014 and he came back a couple of weeks later, but then the big gap for him was he left in March 2014 and didn't return until June 2015, over a year later.
Yeah, that's not a leave. All right, I'm going to deny the TRO. That's the only two defendants, right?
My
Mr.
client,
Mraz.
Mraz was just, go ahead. I'm sorry.
It's okay. Yeah, the third one is Mr. Mraz for tortious interference.
I'm going to deny the TRO for him as well. But you can obviously set this for temporary injunction if you decide to.
All right, Your Honor. Thank you for your time.
Thank you, Your Honor.
All right, thank you. Just get me an order on that denying the TRO, okay?
Yes, sir.
Thank you. All right. Let's go ahead and end this. Cheers. Okay. Is Hunter there? Let me see.
Yeah, Judge, yeah, I don't know, my video camera. Oh, you're still on YouTube, by the way.
Oh, I thought I turned that off. Okay, let me try again.